Hey, it's your girl, your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Doc Talk 24/7. Hey guys, so this video is going to be over the Maryland peace orders to kind of give you guys an idea of how Maryland peace orders work. So let's hop right on into it. So pretty much whoever filed that peace order against Ronnie, we all know that it was on Black Friday in which the courts was closed. And so in order to actually file the paperwork, it would had to be filed with the commissioner because the court was actually closed. And in the last video, I did break down as far as how it works as far as the hearing. You'll have the immediate interim hearing, then the temporary order hearing, and then the final order hearing. But there has been questions as far as what actually does the peace order refrain the respondent or the defendant from doing. And that's what we're about to see right quick. So here are the forms. Let me go back. So here it tells you exactly how to get a peace order. So you have to complete a petition for the peace order. You would have to complete a addendum to that peace order as well as a peace order supplemental form. And there are certain questions that they will ask on the form that relates to the situation. So as far as the piece was, now I'm going to break it down, even further, but this is what the petition for a peace order is going to look like. You fill it out either for yourself or on behalf of any minor children, or you know yourself and the minor children, or an employee, whatever the case may be. They will ask you exactly what type of acts happened within 30 days from filing that petition. So nothing over 30 days counts. So it has to be within the last 30 days. You'll put the kid's information, and then you will petition the court to put in orders to refrain a respondent from doing something or asking the court for them to do something. So, for instance, they may want to order them not to commit or threaten to commit any of the acts that were listed above. So, the kicking, punching, threats of violence, harassment, stalking, so on and so forth. Not to contact, attempt to contact or harass, not to go to their residence, not to go to their school, not to go to their workplace. You can also ask the court to order the respondent or the defendant to go to counseling, to go to mediation, and or to pay the filing fees and court costs for this case, and any other specific relief that you deem is necessary for them to stop committing those acts. So that is the petition. The addendum is just pretty much a description of the respondent. And then we have the supplement documentation. And this is like very specific questions because I got to see how to handle the case. So, whether it's dating violence, they ask, do you contend that you are or were in a dating relationship whereby the respondent engaged in a course of conduct with the intent to unalive, injure, intimidate, or harass you in a manner that placed you in a reasonable fear of death, or, I'm sorry, of unaliving or physical harm? SA, do you contend that the respondent engaged in an essay against you and without your consent that placed you in fear of physical harm or danger? And then the third section is stalking. Do you contend that the respondent has engaged in a malicious course of conduct in which the respondent approached or pursued you with the intent to place you in reasonable fear or serious bodily injury or unaliving? And so all of these documents are, so all three, the petition, the addendum, as well as the supplement document, is necessary and has to be filed in court, in which it has. Now, as far as the process goes, I found this information. I'll definitely post it, so you guys can go read it for yourself. But it shows exactly what peace orders are, how it applies to employers. But here are the acts. Here are the acts that are covered by the peace order. So, an act that causes you seriously bodily injury, kicking, punching, choking, pow-powing, stabbing, shoving. Those are examples. There's plenty more. An act that places you in fear of serious, imminent bodily harm, assault in any degree, false imprisonment, harassment, harassment, and harassment can include. I like to pull up the statutes. Um, let's see. With an intent to harass, alarm, and annoy the other after receiving a reasonable warning or request to stop by or on behalf of the other and without legal purpose. So that's pretty much what harassment is. All right. Um, let's see. Stalking. I just clicked. I'll just go back on that one. So for stalking means a malicious course of conduct that includes approaching or pursuing another where the person intends to place or knows or reasonably should have known the conduct would place another in reasonable fear of serious bodily injury, in assault in any degree of grape or offense as defined by section 3-303 or 308 of the title, false imprisonment, unaliveling, like that a third person likely will suffer any of the acts listed in number one, which is this. Stalking can occur that, so stalking in a manner can be in person, it can be in electronic communication. It can be through a use of a device that can pinpoint or track the location of another without the person's knowledge or consent. I mean, it states it right here. um, Let me see. So stalking, I'm gonna just pull this up for giggles. I should have it pulled it up. So electronic communication means the act of transmitting any information, data, writing, image, or communication by the use of a computer or any other electronic means, including communication that involves the use of email, an instant messaging service, an internet website, a social media application, a network call, a facsimile machine, aka fax machine, or any other internet-based communication tool. So electronic conduct means that the use of a computer or computer network to build a fake social media profile, pose as another, including a fictitious person in electronic communication, decimate or encourage others to decimate information concerning the um, that type of activity, decimate or a real or doctored image of a minor, engaged or encourage others to engage in a repeated, continuing, or sustained use of electronic communication to contact the minor, make a statement to provoke a third party to stalk or harass a minor, or subscribe a minor to a that type of website. It talks about instant messaging. Interactive computer services means information service system or access software provider that provides or enables computer access by multiple users to a computer server. I don't think that has anything to do with it. Social media application means any program, software, or website that allows a person to become a registered user for the purpose of establishing personal relationships. So this is really kind of like those catfish or those predators that be using social media to whatchamacallit. But here, right here, this is what I was looking for, a social media profile. So a person may not maliciously engage in a course of conduct through the use of electronic communications that alarms or seriously annoys whether another. So with the intent to harass, alarm, and annoy the other after receiving a reasonable warning to request to stop by or on behalf of the other and without a legal purpose. Okay, so you can't use social media to harass somebody. This is the biggest one here. You cannot use social media to harass someone. So that is included. All right, let me go back to what I was looking at. Okay, so those are acts under the social media. So to answer those questions, what we just read, that would be considered harassment and stalking. Even if you're doing it via social media. Trespassing, malicious destruction of property, misuse of telephone facilities and equipment, misuse of electronic communication or interactive computer service, revenge porn, and criminal visual surveillance. Um, let's see. The filing fee. How do I get protection? All right, so here's the first step. The first step is getting the interim peace order, obtaining immediate protection when the courts are closed. So, like I said, this is like a emergency, uh, temporary restraining order in a sense. Okay, the courts was closed, so they had to go to the commissioner's office, which is available and open 24 hours a day, 7 days a week. So that's how they were able to file the petition for a peace order, and that's why it had a default time of 12 a.m. And as you see, I did pull up other cases where that default time was 12 a.m. So this is not something that was planned or set up. It is just simply the default time. So an interim peace order was filed on 11/29. Today, they had the temporary orders hearing, which was granted for 7 more days. The final hearing will be done on December 10th. So these are the instructions on how this pretty much works. This is how it works. So they filled out the petition, they filed it with the commissioner's office. Let me see. What relief may the commissioner order? All right. So we're not talking about the we're talking about the commissioner, not the actual judge, but the commissioner. So it says, depending on the specific circumstances of your case, the commissioner may order any or all of the following as relief: refrain from committing or threatening to commit an act against you, refrain from contacting, attempting to contact, or harass you. So I think where it says on the docket, I believe it said, hold on, let me go to here. I'm going to my page to see exactly what it said. Oh, snickerdoodles. I thought I had it on there. Um, Okay, yeah, so it says shall not contact. So I'm assuming that all of that is the same in the same category. So if it says refrain from contacting, that means that you can attempt to contact and you cannot harass them. All right. The commissioner can also order for the respondent to refrain from entering their residence and remain away from their job, school, or temporary home. Let's see. And then it says contents of the interim peace order. The commissioner will forward the interim peace order to law enforcement as well as the district court. Then a law enforcement officer will immediately serve the respondent with a copy of the interim peace order, and that peace order will state the date, time, and location of the hearing for a temporary peace order and a tentative day, time, and location of the final hearing of the final peace order. So once this, as y'all can see here, this is for Maryland, it states that a law enforcement officer will immediately serve the respondent with a copy of this peace order. So anybody, can't say that I don't know that I have court in the morning. Everybody know who I'm referring to, because a law enforcement officer personally hands you a copy of that peace order. So you know the date and the time you have to show up for both of these hearings. Because otherwise, if they didn't do their due diligence, then these peace orders are going to get thrown out the window because you will say, well, I was never served. Hmm. How long would the interim peace order stay in effect? They expire at the end of the second business day after issuance. So if we know it was filed on the 11/29, which was Black Friday, and then we have all day Monday and expired on 12/3. And 12/3 was the temporary hearing. Temporary peace order hearing, you must attend a temporary peace order hearing to extend the length and scope of protection contained in the interim peace order. If the other side has not received a copy, aka if they have not been served, the court will issue a temporary peace order and serve the defendant with a written notice of a final hearing. All right, so the step 2 is the temporary peace order. So they already did this. Let's see. Da 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 da. All right, so they don't have to see the clerk because they already have an interim peace order. So seeing the judge. So whether you received an interim peace order or submitting a petition for the first time, you will appear before a judge to explain the reasons for seeking relief. As the person seeking relief, you hold the burden of proof by reasonable grounds to establish that an act or an incident occurred between you and the respondent. As such, it is important that you disclose any proof of abuse or harassment you may have, including pictures, police reports, medical records, witnesses, etc. Unlike a protective order, the judge must also find it likely that a respondent will commit a similar crime in the future. All right. Now, what relief can the judge order? Because, mind you, when the interim peace order was filed and granted, it was by the commissioner. Now we're talking about temporary orders, which was heard today. So, what relief may the judge order? So, depending on your specific circumstances, the judge may order any or all of the following: refrain from committing or threatening to commit an act against you, refrain from contacting, attempting to contact, or harassing you. We have already looked at what harassment includes. Okay, that does include social media. Refrain from entering your residence and refrain from your job, school, or temporary home. What happens if the respondent appears in court for the temporary orders hearing after have been served with the interim peace order? The court may proceed with a final peace order hearing, provided that the court has personal jurisdiction over the respondent and the parties expressly consent to waive the temporary peace orders hearing. How long would the temporary peace order remain in effect? The temporary peace order remains in effect for not more than 7 days after law enforcement has given the respondent a copy of the order. So that means he has to be served. If the court is closed on that day that the order is due to expire, the order remains in effect until the second day on which the court is open. The judge may extend the order as needed up to 30 days to serve the respondent or for a good cause. Now, the final peace order hearing, um, they have to attend. They have to attend the final peace order hearing to extend the length of scope of protection contained in the temporary peace order. The judge will schedule another hearing that will be held in 1 week. So, the final peace order hearing. So in Ronnie's case, like we said, the final orders is December 10th. That's the hearing. At the final peace order hearing, if the respondent has been served a copy of the temporary peace order, which was today, 12/3. So Ronnie has to be served with the 12/3 temporary peace order. So if he was served with the temporary peace order but fails to appear for the hearing, the person who filed it can ask the judge to enter a peace order against the respondent, which is called a default order. This is just like if a petition has been filed, the person has been served, but that person fails to respond to the lawsuit. What happens? They can enter in a default judgment. This is the same case. A petition for a peace order has been filed, temporary orders have been issued, and the respondent has, they have been served. However, they did not make it to the scheduled court hearing, that final order hearing. The petitioner can say, okay, I would like to enter in a peace order against the respondent because they failed to appear for court. Now, if the respondent is present at the hearing, the respondent may or may not be represented by a lawyer. When the case is called, both the petitioner and the respondent will have a chance to tell the judge exactly what happened, which led the petitioner for filing the petition. It is a formal hearing and the rules of evidence do apply. So the person who's asking for relief always holds the burden of proof by a preponderance of evidence. I've always stated that. So you have to come with proof, pictures, videos, witnesses, whatever. The judge who hears the case may not be the same judge that presided over the temporary peace order hearing. So it is important that you repeat all the reasons why you are seeking relief. This includes submitting into any evidence of any documentation of the act or incident. So, example, police report, hospital records, photograph, witnesses, um, whatever you have, videos, and obviously it says calling witness on your behalf. Beware that the respondent or the lawyer will ask you questions in cross examination and will have an opportunity to disprove your case. Do not be surprised or upset if the respondent lies about what happened. At the conclusion of the hearing, the judge will decide whether an act occurred and whether it is likely that the respondent will commit a similar act in the future. What can the judge order? If the judge finds in your favor or the petitioner's favor, the judge may order one or all of the following: refrain from committing or threatening to commit an act against you, refrain from contacting, attempting to contact, or harass you, refrain from entering your residence, refrain from your job, remain away from your job, school, temporary home, direct the respondent to participate in counseling program, and if the parties are amendable, mediation, and order either party to pay the filing fee and costs associated with this proceeding. The petitioner and the respondent will each receive a copy of the peace order at the time of the hearing. If the respondent fails to appear, the court will mail him or her a copy of the peace order via first class mail. They have to keep the order with them at all times. How long does the final order, peace order, remain in effect? The peace order is effective. The final peace order is effective for a period stated in the order not to exceed 6 months. And then we did read that there may be a possibility that they can extend it. And I'll read that in just a second. Mutual peace orders. The judge may issue a mutual final peace order if both parties filed a petition for a peace order, and the judge makes a detailed finding of fact by a preponderance of evidence, meaning more likely than not that both parties committed an act and both parties are likely to commit an act of abuse in the future as described by the statute. Now, as far as extending a peace order, it says after a hearing and good cause shown, the court may extend the length of the peace order by 6 months. The form you use to make this request is available at the clerk's office. So, if let's say it's approaching that 6 months time and you feel that the peace order needs to be extended, you're going to have to get another form, fill it out, and submit it. Now, if the peace order is violated, if the respondent continues to harass or contact you, call the police immediately. If the respondent does not follow the peace order, the respondent may be found guilty of a misdemeanor and be subject to a fine of up to $1,000 or a jail sentence of up to 90 days. The penalties are increased for a second and subsequent offense of violating the peace order. And that's the process. So that is where we are at. So, so I hope this video helps. If you have any questions, definitely feel free to hit me up on my YouTube IG channel, which is Yourfavparalegal_Cassandra. Don't forget to like, share, and subscribe this video. Until then, you all be blessed, and I'm out. Bye.